Good afternoon, members, and welcome to this first reconstituted Overview and Scrutiny Board meeting. And for anybody watching online, very warm welcome to you and thank you for joining us. My name is Councillor Steve Bartlett and I'm the chair of this Overview and Scrutiny Board. Without further ado, I will invite our Democratic Services Officer to give us a brief on how the meeting will be conducted.
Thank you, Chair. Please note that this meeting of the Corporate and Community, the Overview and Scrutiny Board is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion in this matter lies with the Chairman. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point along Bradley Road. Finally, please could everyone ensure that background noise is kept to a minimum and mobile phones and other devices are turned off or switched to a silent setting for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on laptops. Thank you.
Thank you, Claire. Agenda item 1, apologies. Do you have any apologies, please, Claire?
We've received apologies for this meeting from Councillor Walters, who is being substituted by Councillor Andrews, and Councillor Rice will be joining the meeting virtually.
Thank you. And substitutes is Councillor Marcus Andrews for Councillor Walters. Thank you. Agenda item 3, declarations of interest. Members, does anybody have any declarations of interest? It seems not. No, thank you, members. Public issues. Claire, do we have any public issues? Yeah.
Thank you, Chairman. We've received no public questions or petitions for this meeting, but we have received 3 public statements from Mr. McKinstry. He's not able to attend this meeting, so I'll be reading those statements out on his behalf. The statement in paragraph 8 of today's report that all 12 Conservative councillors have sought this call-in, but no member of any other group nor any unaligned member, suggests that this is a political exercise. And this is supported too by the fact that the Conservatives were planning their own PSPO before the elections, and that their own clauses, which would have criminalised sleeping in vans or overnight camping, have now been removed. It seems reasonable to assume that the group is now trying to get its own back, possibly to woo the hotelier vote. Procedure rules 4C 14.2 and 14.7.2 of the Constitution state that the call-in should only be used exceptionally and not for purposes that are vexatious or improper. I trust, therefore, that statutory officers are watching for any sign of scrutiny being manipulated for political grandstanding or political vengeance. The second statement reads as follows. Regarding the call-in claims, contrary to what is alleged, Councillor Wilson cited 2 lines of possible legal challenge at July's Cabinet. The first being that a PSPO banning sleeping in vans is challengeable under negative equality impacts. Such grounds were indeed cited by Sarah Ward when she sued this council over an earlier PSPO, penalising homelessness, in 2019. Secondly, Councillor Wilson described how behaviour needs to be detrimental, not merely inconveniencing, to justify criminalisation. With open fires and excretion already targeted under a separate order, what remains is the potential criminalisation of sleeping in a tent or van. The idea that these activities could wreak a detrimental effect on the quality of life in the locality as required under section 59.2 of the Anti-Social Behaviour, Crime and Policing Act 2014 is laughable. Cabinet acted wisely, therefore, in rejecting these disproportionate proposals. The third statement reads as follows. Finally, I want to address the claim, again in paragraph 8, that exactly the same PSPOs have been implemented by other councils without legal challenge. This remark is disingenuous, as section 66.7 of the Anti-Social Behaviour, Crime and Policing Act severely limits the way in which interested persons such as residents or visitors to an area can challenge PSPOs once implemented. Such applications can only be made under section 66.2 of the said Act, a procedure which is little known, time limited to 6 weeks, and subject to legal aid only in very narrow circumstances, following the decision in Liberty versus the Director of Legal Aid Casework 2019. It may be this matter, rather than mass concurrence, that explains the paucity of legal challenge which the Conservative group is so swift to cite. Thank you.
Thank you, Claire. So agenda item 5, the call-in on a cabinet decision. Now, on the 4th of July 2023, approved 2 PSPO public space protection orders. A valid call-in request submitted by 12 members was received. and we are here to decide not on the decision taken, but whether the decision was taken in accordance with the decision-making process detailed in Article 12 of the Constitution. I'd really like to emphasise that, members. So when we come on to the debate, we will be looking at Article 12 and the specific paragraphs that apply to the call-in. Okay, so with that, I'm going to ask Richard Jones, our Democratic Services and Fellows. I believe you're our acting monitoring officer at the moment. Congratulations, Richard. To give us a bit more information on the call-in process. Thank you.
Thank you, Chair and members. And just in the first instance, if I can just explain to members, particularly new members and any members of the public watching the call-in process, that may be just considered to be a little bit useful. Call-in is a mechanism, it's a legal framework. It's a mechanism which operates in local authorities operating executive models of governance. And that's what we have with the Cabinet. It affords non-executive members the opportunity to hold the executive to account by referring a decision which has not yet been implemented to the overview and scrutiny for consideration. The call-in procedure is set out in Part 4C of the Constitution. A valid call-in request must comply with the following requirements. It must, 1, have the correct number of signatures, and 2, give reasons for the call-in. The reasons must set out the grounds upon which the call-in is based, be legitimate, and not designed to create an obstacle or delay the proper transaction of business. In this instance, the prerequisite number of councillors signed the call-in and was therefore accepted by the monitoring officer as a valid request. And with regards to the grounds for call-in, the submission claims that the decision was not made in accordance with the principles of decision-making as set out in Article 12 of the Constitution. There are 10 principles in Article 12 which have been reproduced for ease of reference in paragraph 7 of the report. The call-in references 3 of these principles as the grounds for the call-in together with the reasons, and these are detailed in section 8 of the report. As the chairman said, it's important to note that, sorry, that's my next paragraph. It's important to note that it is not the role of the monitoring officer to determine whether the grounds or reasons provided in a call-in have merit, but to simply validate that the grounds and reasons are sufficient to refer to the board. It is not for the board to consider the merits of the decision reached, but to determine whether, as the chairman just alluded to, in this instance, whether the application of the 3 principles of the decision making cited in the call-in warrant advice from this board to Cabinet. The options before you are, if you wish to offer advice, then if you do offer advice to the Cabinet, the Cabinet is obliged to consider that advice and must reconsider that matter, but it is at their sole discretion whether or not they take that advice, and any decision they reach, whether that is to uphold the original decision, make modifications or change that decision, are not then subject to a further call-in process. If you decide not to offer any advice to Cabinet, then the decision may be implemented immediately after this meeting. Appended to the report, the decision was made by Cabinet on the 26th of July, and appended to this report is a copy of the Cabinet decision record that was published on the 26th of July, an extract of the minutes of that Cabinet meeting, and the original report considered by Cabinet at that meeting, together with a further 7 appendices that were appended to that report, including officer decision records, consultation documents, the consultation report, options appraisals, enforcement protocol, the proposed order, and an equalities impact assessment. I'll hand it back to you, Chairman.
Thank you. I'm going to be calling on Councillor Broadhead in just a moment to put the case for the call-in. But there are 3 specific paragraphs of the decision in Article 12 of the Constitution. I'm going to read them out. B, subparagraph B, ensure that the decision and the decision-making process are lawful. E, have due regard for appropriate national, strategic, local policy and guidance. And H, explain what options were considered to give the reasons for the decision. So that's the one thing we're looking at in detail after we've listened to everybody. So first of all, I'll invite Councillor Broadhead to make the case for his reasons and give the reasons for the call-in. Thank you.
Thank you very much, Chairman, and thank you to members of the board for considering this call-in. Colleagues that are new will note this is, although this is the first call-in of the new term, we have had a number of call-ins to the preceding overview and scrutiny boards, both when I was chair of the board and also when I think when the chair was chair of the board previously as well. And as we've heard, it is not about the decision itself, but the decision-making process, and for us to look at whether we've got confidence that the reasons given, the evidence, have followed that process. Chairman, I've said a number of times that it's absolutely within the administration's gifts to change policy as they wish. But as we've said, those options have to be evidenced and credible, and also crucially to set out the options that have been considered in enough detail that we can have assurance that those decisions have been taken correctly. And as you've highlighted, the Constitution is pretty clear about the principle of decision making set out in Article 12. And I think in particular, we've highlighted 3 areas that we have some concern on with these 2 decisions. The main one, incidentally, around the options considered and the reasons given for the decision. And what I think is a pretty clear case that there are not adequate detail in the decisions that have been considered. I think there's also a case to be made for it not according with our local policy and guidance. In particular, within our corporate strategy, we have our connected communities to ensure our communities feel safe, and also with the reference to the lawfulness, as we heard in the original cabinet decision, there was a reference to the fact that this decision couldn't be enacted because there might be legal challenge, but we saw no evidence whatsoever in the report of that legal challenge, and that's what I'd like to talk about this evening. Although it's not about a decision, I do think it's worth a very quick background of the proposed PSPOs. This is not something new. This was a consultation process that was started before the election, and it was in relation to an issue that has been brought to our attention by residents for a long time. You've heard from the public statements at the beginning the idea that this was about criminalising behaviour. It's absolutely not what it's about. We have a number of situations of things that are currently unauthorised, and the 2 that we're talking about in particular, overnight sleeping in vehicles and beach camping, have been unauthorised by a collection of policies and bylaws for some time. But we have not had the ability as a council to adequately enforce that unauthorised activities. So the PSPO was around giving the council powers to be able to authorise things, to enforce things that were already unauthorised, and not about criminalising activity, and indeed talking about homelessness in particular, which has been referenced as a concern. We have really robust policies around homelessness already in place in the council, and certainly the advice that we'd received when we were undertaking this consultation was that this would not conflict with those policies. So this wouldn't be about punishing people who were homeless. If people were homeless, then they were homeless, and that is dealt with in a certain way. This is about something entirely different. So, Chairman, 2 real reasons in total were given for the decision not to proceed with these PSPOs, which had been consulted on by the previous administration. The first was around the decision not having the support of the public, and therefore it wouldn't be proceeding. And the second one, as we mentioned, was that there could be some legal challenge faced if they were implemented. And I'll take those in turn. The first argument that these 2 particular PSOs do not have public support is frankly not borne out in the consultation results, particularly if you take the residents, which we are here to actually represent. So in that public consultation, there were 1,574 responses, and in the section on preventing unauthorised sleeping in vehicles, etc., 75% of our residents agreed that was the correct course of action to be taken, and indeed in the proposals to enforce the unauthorised overnight beach camping, again, over 3/4 of our residents thought this was a good idea. And Chairman, that's not surprising, because we embarked upon this proposal initially in this consultation process precisely because again and again and again residents have been saying to us, first of all, why aren't we stopping this, even though it is unauthorised? But secondly, it is simply not fair that visitors, because we're not talking about homeless people, we're talking about visitors, can just come and sleep on our beach for free in our open, beautiful open spaces, or indeed park in areas that have signs saying that you're not allowed to sleep overnight, and we're not doing anything about it because we don't have adequate enforcement abilities. The reason in the paper that this resident support could be ignored is because a very high proportion of our visitors thought that it was a jolly good idea to be able to rock up onto Poole, Bournemouth and Christchurch beaches and camp for free, and also to pull up in a motorhome on our cliff tops and again park for free. Chairman, that's not particularly surprising that anybody consulted on holiday would like the ability to have a free holiday without enforcement, but actually that is not the view of our residents. And the big question I pose to the board is, who are we here to represent? Are we here to represent our visitors that want a free holiday, or are we here to represent our residents that have said for too long we have not had these enforcement powers, and this PSPO would have enabled that to take place? Chair, the second kind of bone of contention or reason that was given by the cabinet member for not proceeding was actually given more verbally in the meeting itself, where there was a point made that we could face some legal challenges if this was implemented. And the real issue with that statement is there is absolutely no exposition of that whatsoever in the cabinet paper. There is no detailed option around actually if you did this, these are the challenges that you might face, because that could well be a credible reason not to proceed with the policy. If there was a very real challenge set out in detail with evidence, with examples of the fact that this was simply not doable, then of course that would be a credible reason not to proceed. But not only was that not set out in the report, and therefore I would argue that it does not comply with the decision-making process as outlined in Article 12, but actually again the extensive work that the previous cabinet members and officers had done prior to this consultation, a number of other councils having almost identical powers as this, which have been successfully implemented and also has not been successfully legally challenged, I think shows that the argument doesn't stand as well. So I think there's many other points. I've raised the three points that we had raised around where we do not think it corresponds to good decision making, but I think it comes down to two main points. If you're going to quote legal challenge, where's the detail? There's none there. And if you are going to say the public doesn't support it, whose side are you on, the residents or the visitors? Thank you, Chair.
Yeah, thank you, Councillor Broadhead. Are there other members who signed a call in wish to speak? Councillor Haynes, would you like to come up? Thank you. You could just contain that within 5 minutes if you can, please.
Yes. Thank you very much, Chair. I won't be long in what I have to say, because Councillor Broadhead has already covered quite a bit of what I wanted to say. I want to endorse what he has said, but also to draw members' attention to, well, I'll say page 59 in your report pack, but it's actually page 5 of the consultation response document, 3.2, and there you will actually find all the percentages of the responses that have actually been received, and that bears out exactly what Councillor Broadhead has actually referred to. That, contrary to what was actually said, I think in coming to the decision that we're now looking at, I think there is the evidence there from our residents, if we take into account the percentage of local residents as opposed to people out of the area, that they do actually want this, and they do not see this as criminalisation of these activities. And the other point I wanted to make, it relates to the legal challenge. After the meeting and after what I would refer to as a rather disappointing outcome, that this part of the PSPO was not going to be taken forward, I did some further research, and our neighbouring authority, Dorset, actually have something very, very similar in place. They also had this issue about potential legal challenge, which they have managed to overcome, because if you can actually word your order in a manner that will not unfairly target the vulnerable groups, which is what the basis for the legal challenge could potentially have been. So I think that there hasn't been sufficient research, and I think some of the information that we have been told, i.e. that there is no evidence or there is evidence, it's not consistent because it has been done by other local authorities, and our next door neighbours, Dorset Council, have in fact actually put this into place without any issues or legal challenge. So I would ask members to actually take all this into account in coming to your decision on this. Thank you very much, Chair.
Thank you very much, Councillor Haynes. I'd like to invite Councillor Karen Wilson, who would like to respond to the call-in argument. Thank you.
Thank you, Chair. And thank you for those who have spoken already. So I'm going to go through step by step very briefly, because I want to open it up to questions from members, but starting with each part of the process. So the first item is around ensuring that decisions and the decision-making process are lawful. Counsel and legal opinion was sought and received throughout the PSPO process, which was stated throughout the report. The requirements to implement PSPO are set out in sections 2 to 4 of the Cabinet report. And at section 4, you will see that a requirement for behaviour to have a detrimental effect on the area. Now that's a key word, because detrimental is very different, particularly from a legal point of view, to inconveniencing. So while the act of sleeping might be an inconvenience to some, it can't be considered as detrimental. And that was on the basis of counsel advice, so external expert legal advice. It's not just me saying that. And as well, in addition to this, other behaviours covered in the PSPO cover the other behaviours associated with the sleeping on the beaches. So that's the first part, but also just lingering on this principle a little bit longer while I've been thinking about it. I don't think this principle actually, I think it's to make sure that the decision and the decision making process are lawful, not that we're being extra careful to do something that is not unlawful. You know, if anyone can, if any member can see what law I've broken in my decision making process or my decision, because I think that's what this principle is there for. Moving on to item number 2 in the Constitution, to have due regard to the appropriate national, strategic, local policy and guidance. Now, I of course took into consideration all of the relevant policies and guidance, but I paid particular attention to the government's updated guidance from June 2022, and I'm just going to read you that guidance. Public spaces protection orders should not be used to target people based solely on the fact that they are homeless or rough sleeping, as this in itself is unlikely to mean that their behaviour is having an unreasonably detrimental effect on the community's quality of life, which justifies imposing restrictions using a PSPO. Councils may receive complaints about homeless people, but they should consider whether the use of a public space protection order is the appropriate response. These orders should be used to address any specific behaviour that is causing a detrimental effect on the community's quality of life, which is within the control of the person concerned. So again, I think that is, for me, pretty clear as to why we haven't implemented that part of the PSPO. Thirdly, moving on to the last highlighted decision-making principle, to explain what options were considered and give the reasons for the decision. Well, at section 19 of the report, there is a clear options appraisal, which states, following consideration of public consultation feedback, further evidence assessment, a key point, and evidence from legal counsel, the initial proposed causes have been revised and follows. Then it sets out the options and the reasons behind them. So they're the 3 highlighted things that the call-in highlighted in terms of our decision-making process. But then further to that, there are other clauses within the Constitution, Article 12, which I would like to just go through quickly to state that we also followed those. I think we were very clear about what we wanted to happen and how it will be achieved. We considered we considered the public sector equality duty and its obligation under the Human Rights Act. We carried out an equality impacts assessment, and that's what led us to not bring in the PSPOs, which potentially infringe on the rights of some of the most vulnerable in our society. There was also a challenge, a legal challenge, potential legal challenge, around whether we were in violation of Section 6 of the Human Rights Act 1998, in that it is an obligation to be part of the to follow and not infringe on the Human Rights Convention, and Article 8 of that convention affects this specific PSPO. Then moving on to item D of the Constitution, to consult properly and take professional advice from officers. Well, we went out to a consultation. We've laid that out within the body of the report. And I've taken advice from officers. This has been a really long process for me. This is something that I inherited from the previous administration. I sat down, I spoke at length with officers, went into detail about the different parts of it, and came to a decision. Again, item F, to ensure that action is proportionate to what the council wants to happen. I believe that this is proportionate to what we want to happen. We want to be making our beaches, our coastal spaces, as well as our open spaces safer and cleaner, but we don't want to be discriminating or infringing upon rights, and potentially unlawfully so, of those who are vulnerable in our society. Ensuring that the decisions are not unreasonably delayed. Unfortunately, that one was out of my hands, but I think we did everything in a timely manner. And making the decision public, unless there are good reasons for it not to be, and we've done that. Finally, the last one is around taking into account the Counter-Terrorism and Prevent Act, and I think we have done that, although it was not really applicable to this. So yeah, I'm happy to leave it there and open up to questions. Thank you.
Thank you, Councillor Wilson. So, members, it's down to you now. Would anybody like to open? Councillor Tarling.
Sorry, just a point of clarification. Councillor Wilson, options appraisal, I missed the section where, if you could just repeat the options appraisal section.
Yeah, so it's section 19 in the main body of the main report that went to Cabinet. So that should be in your agenda pack. There is also a full document. So this is kind of a brief overview, but a very clear one. But there's also a full document in the appendices as well.
Anybody else? Sure.
Councillor Andrews.
Yeah, Councillor Andrews.
Thank you very much. Yeah, the decision's been challenged on 3 grounds. Can I just get some clarification as to whether all 3 of those have to be accepted or sustained, or is it only one of those fill the criteria for the call-in?
I don't believe that all 3 have to. It's up to us to decide. Any one of those would, if you found, would be sufficient to refer it back to Cabinet, I believe. Yes, Councillor Trent.
Thank you, Chair. I must say that I read this over and over again and I couldn't actually work out what the call-in was about, because when I read the notes, I got the impression that it was actually going to be looked at and some alternative proposals come forward that would deal with the issues, specifying sites to be protected. I take the point entirely about homelessness because, there are at least 2 sites in my ward that I'm aware that people have been sleeping in vans because they've got nowhere else to go. And, but it's been quietly tolerated and they've gone away and moved on, sort of thing. But, I do feel that, it needs to be looked at in a little bit more detail, and it shouldn't be a blanket ban. And that you know, I thought that that was in hand, although maybe I'm misinterpreting what I've read, because I read it that it was actually going to be looked at in detail over a period of time, and something a little bit more specific would come forward. So such is the joy of interpretation.
Councillor Wilson, do you want to come back on that point? Thank you.
Yeah, I'm happy to. I think what you're trying to say, Councillor Trent, without putting words in your mouth, is probably that we're leaving this decision. We're constantly reviewing this decision. So as I stated in my opening, there needs to be a body of evidence in terms of reporting and incidents in order to consider something for a PSPO to have it to be considered detrimental and repetitive. And so, yeah, we are constantly assessing the evidence before us. But yeah, there isn't anything more to say on that, really.
Can I also follow that up, Chair?
Yeah, please do.
That there does seem to be quite a big difference in the respondents between different sort of generations, and obviously that was taken into account. But I'm pretty certain that, you know, maybe at some time in the future there will be specific roads, you know, that, like taking the point about the cliff top or the edge of the beach on the shore road or something like that. But you know, I'm personally quite happy if it does get looked at in a little bit more detail and something comes forward that is more sort of tailored to what's needed.
Thank you, Councillor Moore. Thank you.
Yes, thank you, Chair. Well, the report says, and the portfolio holders just told us, that Liberty made a formal representation. So could you let me know how serious do you think that legal challenge was or would be? Thank you.
Councillor Wilson.
Yep, I think it would be very serious. But I'm happy to bring in the officer on this, because I suppose this is more of a technical one on the probability of legal challenge and such like.
Thank you. I'm Sophie Sajic. I'm the Head of Public Protection. I'm the lead officer for this report. So the Liberty Challenge laid out quite clearly that they were looking to challenge the PSPO specifically around the evidence. So it might be worth setting some context to this. With regard to sleeping overnight in open spaces, there were 34 incidents between July 21 and July 22. Of those 34 incidents, 6 incidents had associated fires and 7 incidents of litter. Both of those behaviours are managed by either alternative PSPO clauses or primary legislation. When you look at highway incidents, there were 72 over a 2.5-year period, of which 5 of those had detrimental impact attached to them, 3 of which were urination and defecation, and 1 was drug use. Again, primary legislation or alternative clauses around that. And when it comes to beaches, 169 reports. However, within that, the detrimental impact of it was only 3 of those incidents. Those incidents included urination and defecation, fires, litters, and antisocial behaviour, all of which are included by either alternative clauses or within primary legislation. So that would be your littering and your littering contract. With regard to the Liberty advice, it does make it very clear with examples of case law around the element of behaviour being required to be detrimental. So not, as Councillor Wilson has said, not merely inconveniencing, but there has to be significant justification that the behaviour is so detrimental, and this isn't the act of sleeping, this is the associated behaviour with it. The act must be so detrimental that it justifies a blanket ban and a prohibition of such scale. We've got 14.7 miles of coastline, so the scale of that impact has to be so significant that it justifies a blanket ban. Both Council advice and Liberty guidance made it very clear that not only did we not have the evidence of that detrimental effect from what they could see, but also that they were looking to legally challenge us, and the Council advice supported that challenge was very real in terms of risk. I can quote verbatim if you would like.
That'd be fine. Thanks very much. Councillor Tarling. I'll come on to you in a minute, Councillor Dedman.
Yeah, thank you very much. I thank Councillor Broadhead for bringing this forward, because I think it is very well worth discussing the points, especially about sleeping on the beach, and the points that he made regarding, we don't want to turn into a thing or an attraction for Bournemouth. I have slept on the beach quite a few times in my days. I don't do it anymore, but I wouldn't want to be criminalised for such activity. I think that the key point, and I've highlighted here, is the detrimental impact. But the point we're making here is, as the board, is to check that the decision-making process has been followed, which is the basis of this. Not to, I disagree with Councillor Broadhead here to necessarily represent our residents on the fact of, do we like people sleeping on the beach, fires, littering? I think that's an open door, an open discussion. I think we'd agree that certain behaviours we don't want to see, but that doesn't mean that we need to criminalise them. But the point of this board is to ascertain, has the cabinet followed the decision making process? And as much as we like to get distracted by homeless people or legal challenges, the key thing is, did we follow the process? And I think that the report is very detailed. That was the February report. And the interesting responses therein. It doesn't mean that the committee has to follow verbatim the recommendations of that report. That's what, the cabinet has to follow that report. So, thank you very much.
Yeah, I think Councillor Tarling, I think we understand that point. The point is, do you believe that the process has been followed? And is there, these three specific elements of Article 12, have they been followed reasonably? So that's the point.
That was the question, and yes, I believe they have. But I thank Councillor Broadhead for bringing the motion to the board.
Councillor Dedman, thank you. I'm sorry to keep you waiting.
That's all right. I bow to, well, I don't always bow to Councillor Tarling, but in fact, almost never. Yes, thank you very much, Chairman. I'm interested to hear from Councillor Tarling that he has slept on the beach, because I thought that the point of the PSPO was to prevent people, as I know in Muddyford, driving those massive mobile homes, and they've got their boats, their bikes, everything's on them, and they park in the car park. They park overnight. And I think there was a mention of not only sleeping, but other behaviour being detrimental. It is. But if that's not what this is about, then I'm sorry. I thought it was what this is about. I thought there were, I'm surprised also to hear from the officer that there's not a body of evidence that this is detrimental, because there certainly is from me and my fellow councillor in Muddyford. There is plenty of evidence. However, the bit that I wanted to pick up is on page 4, I think. Ensure that the decision-making process are lawful or is lawful. Okay, so I'm concerned about what Councillor Haynes brought to our attention about the fact that the report that we have got and has been reiterated is saying you can't do it because of vulnerable people, because of all the things that we've just heard. And yet Dorset Council, of course I have a great respect for Dorset, I'm sorry, they're doing it. So I'm concerned that we were told something that is not right. I don't say that the officers were wrong. I'm just saying that there is confusion about what we have been given, or not we, but the cabinet, and what other councils have done. And I fully accept that I will be shot down in flames from behind me. So that's fine.
Councillor Wilson, you wanted to respond? Thank you.
I just wanted to bring Sophie in on this, because obviously,
Thank you, Councillor Wilson. Don't worry, Councillor Dedman, I won't shoot you from behind. So the key element to this is again evidence. So we can't equate ourselves to any other local authority. We are purely looking at the evidence that we have in our own merit within what has been reported through various different processes into us as a local authority. So although other local authorities may have implemented PSPOs, that will be on the body of their own evidence. That will be down to the evidence of detrimental impact of certain behaviours in their area. So it's very difficult to compare one and the other. What I can tell you is that the evidence has been provided in full to Council and to our own legal team, and obviously scrutinised by myself as well. And at this point in time, there is not the evidence of that detrimental impact. So that's the behaviours that sit alongside it. Now, I don't think any of us are saying that it doesn't happen, because we're quite clear that there is sleeping on the beach, there are sleeping in vehicles. But the impact of that behaviour is what is required within the legal test to be hit. Now, this is a movable process if, and the report does clearly say, if we get to a stage at a later date that there is that evidence of that detrimental behaviour, and that we work collectively with our residents and with yourselves as members, and we collate that evidence, this can be reviewed. You know, PSPOs can be varied, and a PSPO sits for a 3-year term. So in 3 years' time, it may well be possible that we're having this discussion again. So what I would say is there's work being done by our officers to look at how we collect evidence and how we best reflect detrimental impact. And I would encourage members to do so as well and report that in to us so that we can review if we need to and the evidence threshold is met.
Thank you very much. Councillor Aikenhead, thank you.
Yes, so I've listened carefully to what everyone has been saying so far, and I can hear that this is a really emotive issue, that it's a issue where people do disagree very much, but I want to try and draw us really seriously into what these 3 reasons are in that it's been called in, and whether we as a committee can be satisfied that the decision was made correctly, because this is not about whether we agree with the decision or not, but whether it was made correctly. And I just briefly talk about them one at a time. The first one, to ensure that decision and decision-making process are lawful. I think that there is absolutely no doubt that we can say it was the decision-making process and the decision are lawful. There has been no challenge to that at all. All the talk about law has been about whether there could be challenges or not, but actually nobody can challenge the decisions that's been made. If anything, people are criticizing it for being overcautious, but B doesn't say that you can't be overcautious. It says you can't make decisions that aren't lawful. So I think that we cannot, as a committee, use that one as a reason for delaying the decision. The next 2 are a little bit more difficult, but it is a matter of deciding whether we do feel that the policies have been considered, and whether we feel that the options were properly considered when making the decision. Now, having listened to what the cabinet members said, I am satisfied that he has given due regard to all of the, and in fact the options, because rather than just deciding to ban it or not, there is this going to be looking into it in the future in terms of whether a designated area can be provided so that you're actually containing it. And I can see that there's some logic in the way that they've been looking into what actually creatively can we do about the problem, rather than just ban it or not ban it. So I think that's good evidence that options were considered. So I'm satisfied after hearing what the cabinet member and officers have to say, that although I really do understand that there's a lot of people who really don't like the decision that's been made, I believe it has been made in the correct way, and that as a committee we don't have any reason to ask the cabinet to consider it.
Anybody else? Councillor Dove, thank you.
Thank you both to Councillor Aikenhead and Tarling, and I hope certainly that their mind isn't closed already before we end the debate, although they've made obviously their current opinions quite clear. First things first is around the decision making, and if it's okay, I'd just like to speak to the decision maker, obviously Councillor Kieran Wilson, and I'm just trying to understand in terms of your decision making how you are measuring detriment, please.
Councillor Wilson.
in accordance to the council advice and the legal advice, and that's how I'm measuring it. Thank you very much.
Thank you.
Right,
Councillor Dove, do you want to
yeah,
come back?
so yeah, that doesn't really answer and it's not particularly helpful. So what we're saying is that obviously it's not an inconvenience, but how are you measuring that it's not an inconvenience and it's detrimental, please? What is that difference in your decision making?
Councillor Wilson?
So inconvenience would be inconvenience is around, you know, for example, cleaning the beaches in the morning and our seafront staff who do that not being able to do that job fully, but that's not detrimental. Detrimental is around harm and the harm it causes. What harm does sleeping on the beach cause? Could that be what would you measure that as?
So I will come to that if I just go through all of this, and then obviously with that, I just don't want to like cover some bits that perhaps you might be covering in a moment. And then you've talked about various thresholds for accepting. So obviously we know that we have some that are being accepted at 70%, but some like the overnight sleeping is at 75%. And there's like in the report it says significant sort of approval, for want of a better words, you know, support for accepting this. So in your decision making, what percentage were you looking at in terms of accepting certain behaviours, please?
Again, to be honest, it was to do with the legal advice and the fact that we would be legally challenged. I don't want to put this council at risk of not only reputational damage but financial implications of a legal challenge. Okay, so that is the main priority. Council advice stated that we did not have the evidence, as has been said by my officers. So that.
Okay, this is really interesting. Can you just remind me what numbers you had for overnight sleeping between, I think it was April and, sorry, I couldn't write it down so quick, April and August, April, October? What were the numbers that were mentioned just a minute ago?
I'm happy to.
Councillor Wilson?
I'm happy to refer to my officer on the numbers. Thank you.
Thank you. Councillor Dove, can you clarify, asking around open spaces, highways or beaches?
If you've got all of them, if you don't mind, Chair, happy to take them so we can get a fuller picture of exactly what impact we're looking at.
Yeah, so
if you don't mind, Chair.
Yeah, okay.
Okay, so overnight sleeping in open spaces, occurrences between July 21 and July 22. Do you want the breakdown of associated behaviours with that as well, where negative behaviours was?
It's entirely up to you, but I don't.
Yeah, I see where you're going with this, Councillor Dove, and you know there clearly is evidence there that there's a problem. Whether we really need to go to the nitty gritty of it or not, I don't know. Let's just see where this takes us just for a couple of minutes, and then if it gets too detailed, I'll draw it to a close. Okay, so Sophie, if you want to carry on with your response, then.
Yeah. Overnight sleeping on the highway, 72 reports between August 2020 and November 2022, of which 3 incidents had urination and defecation attached and 1 incident of drug use. 1 person verified as homeless and 1 was a commercial vehicle. And sleeping on the beaches, 169 reports of sleeping on the beach between the 6th of the 4th, 22 and the 18th of the 9th, 22. 19 incidents that were recorded by council security, 3 of which had verbal abuse when asked to leave. 9 of those were people who were seen as homeless or verified as homeless. 11 resident complaints, of which 9 of them had no associated ASB. And the beach team served 139 notices to vacate, but no associated antisocial behaviour, no associated noted detrimental behaviour attached to that. So just the presence of tents in those incidents.
Absolutely.
No, that's really helpful. Thank you, because it may well have been mentioned and broken down previously in the officer's response. I only heard the 34 previously, and obviously it was very different to the numbers that I had received when I was putting together the consultation. Thank you. I suppose it's really interesting to also understand how officers are understanding this and how it impacts on the work they're doing. And if you don't mind, I've got a very, very short email which talks about the challenges that highways have and the reason why they would support this, if you don't mind me reading that out. It just talks about the fact that we need to have certain measures in place to be able to do that. And then it also then talks about the decision making, because there is a protocol in our decision making of when it goes from highways into ASB and the work that's required around there.
Maybe we can come back to that. I don't want to go down that rabbit hole at the moment, and they're not here and they need to be represented. They should be here to represent themselves.
That's fine. I can talk about
Okay, I'm going to come in now. The members have all had a good crack now. So there's a few things I'm going to raise.
I've got a few more queries regarding the decision making though, because we haven't established all the decision making and then all the reasoning behind why that decision's been made, because there is counter evidence that can be used and implemented which will mitigate some of the decision making that's been made.
Okay, I don't want to go into too much of the decision making, because the outline here are quite simple actually, and I hope to bring it back to some more simple arguments in a minute. But Kelly Ansell wants to come in, so I'll just give her the floor for a moment. Thanks.
Thank you. And actually, it's on the basis of your point, Councillor Bartlett, and bringing it back to simple arguments. So when looking at the basic legal test, really straightforwardly, the evidence has to show that behaviour being restricted has to be having or likely to have a detrimental effect on the quality of life of those in the locality. Quality of life of those in the locality. It picks up on the point around inconvenience. It's about a detrimental effect. It has to be persistent or continuing in nature. So there's an argument there in terms of seasonal fluctuations, and it has to be unreasonable. So the decisions that were taken in terms of how our proposals matched to the legislation were absolutely tested against those very basic principles. So I just ask that members are very mindful of those three very simple points that relate to detrimental effect on the quality of life, that it's persistent and continuing in nature, and it has to be unreasonable. And what we had here was very strong, was very clear advice around from Council around the evidence that we had available. And from my perspective, one of the things that helps me to, kind of clarify this in my mind is that it isn't the action that we're looking to restrict, it's the behaviour, because that takes us straight back to those principles that are noted very clearly in the guidance and in the legislation. It's the behaviour, which actually, many of which are covered, the evidence that we have is directly linked back to the clauses that have gone through and were accepted by Cabinet in relation to the PSPO proposed. So it's not the action that we're looking at, it's the behaviour and the impact of that behaviour. And I hope that's not too simple, but
thank you, Kelly.
Trying to bring it back to some basics.
Is this on this point, Councillor Wilson, because Councillor Devon wants to come in and she did put her hand up before you. Councillor Devon.
Thank you, Chairman. It's about the reporting of incidents, which some of this seems to hang on. In other words, the officers are saying in the report that as we haven't had any reports, sorry to have so many reports here, but as we have had not the incidents given to the council. And I'd just like to give an empirical example of when I tried to report antisocial behaviour to this council a few weekends ago, and it was antisocial behaviour on the beach at Muddyford. But when I got through, finally, to anybody at the council, I was told to phone the police. So that will not have come through to the council. And in fact, I didn't phone the police because it was antisocial behaviour, but there was no threat to life. So I'm very concerned that when we get these reports, that all this is taken into consideration as to how difficult it is to report anything to BCP.
Okay. Right. Yeah, I'm getting this in stereo here. First of all, I think it was Councillor Wilson. Thank you.
I'm sorry, mine's on a bit of a separate point, but it was just around the Dorset PSPO that was mentioned. That was brought in May 2022, I believe, which actually is before the government updated their guidance around it. That guidance that I read out earlier on. Thank you.
Thank you.
Councillor Moore.
Councillor Moore, thank you.
Thank you, Chair. Well, I think that the aim of the proposed PSPO, which covered the overnight camping on the beaches, was to prevent antisocial behaviour and was certainly not to hurt homeless people. But throughout the consultation, concerns were raised around the negative impact it would have on homeless people. That to ban overnight sleeping would be unfair on those that have been made homeless, that people camp due to a variety of circumstances, including homelessness, and queries were raised whether the scale of the issue justified the prohibition. This was all evidenced in the report. And then Liberty made a legal challenge. And I know that the former Poor Council was on the receiving end of a successful Liberty challenge in the High Court against the PSPO a few years ago. And once again, the issues involved the negative impact it would have on rough sleepers. And the case is still documented in full on the Liberty website. And as a former Poor councillor, I remember the council received much adverse publicity as a result of that particular case. So for me, to sum up, basically, it's Liberty made a formal representation, council advice and guidance. The issue of a potential impact on individuals who are homeless or rough sleeping has been identified and highlighted within the Equalities Impact Assessment. So I believe Cabinet made the decision correctly.
Councillor Dunn, one last go, and then
sorry,
I'm going to have a few words, and then I'm going to be asking people to summarise. Okay.
So I'm quite finished. So I think there's been a lot of conflation, which is quite unfortunate because we're not really talking about the behaviours and the impact of those behaviours. The previous PSPO in Poole was actually particularly for targeting those that were rough sleeping. This PSPO was not, and this was about behaviours of begging and criminalising them thereafter.
It was about begging.
This was I just said begging. So this isn't about begging. This is about those who are choosing to come, sleep in our beaches, in our green spaces, defecating, urinating, because all the toilets are closed in those areas. So those associated behaviours are directly linked with them sleeping overnight. And some of the questions I was going to ask of the PFH was, have you spoken to the rangers at Hagensbury Head? Difficulties they have moving people on and knowing that they've left all their human waste behind. Article 8, freedom of a right to family life and freedom and private life. I don't see how that's relevant. In terms of the PSPO and the homeless issues, that has been addressed in the EQIAs. I've seen the documents, I've seen how we're going to, or how had we had the administration could have mitigated that. We could have strengthened and ensured that our rough sleeping programme was there, and first and foremost, that's the policy that we've used. We would need to do a needs assessment anyway, whether they're travellers, homeless, sleeping there, just pulling up for the night. That's what differentiates the different pathways we would take. That's what differentiates in our car parks protocol of when we get involved in terms of community safety point and when highways deal with it in another way. So all of those have been mitigated. I think it's smokes and mirrors. I think we're hiding behind perhaps policies which aren't relevant. The quote that Councillor Wilson gave earlier around, and I'm really sorry, behaviours connected with the sleeping and that June 2022 was specifically about rough sleeping. This is behaviours post-COVID when people are now coming down, fly camping, setting up wherever they want. The fact that it's persistent and also continual and unreasonable. I have countless emails which I could read out to you by officers and by ward councillors, all the way from Cliffhanger Car Park, including yourself at Muddyford Quay and Councillor Hilliard, right the way to Hamworthy, about people pulling up, staying there for the rest of the summer, and from Richard Pincroft saying, do you know what, there's absolutely nothing we can do on this. We just cannot move them on. And we're talking about, well, we've got urination policies and we've got this policy and that policy. They're already unlawful anyway under criminal law. What are we expecting all of our officers to do? Hang around and watch until they defecate or need the toilet? Of course we don't. But there will be a body, unfortunately, of evidence left behind where there's camping going on behind the beach huts. I know it's a gross subject, but it's the reality of what our officers have to deal with in clearing this up. Whereas we could then just say, do you know what? We need you to now move on, because we won't have got the evidence in the first place to have then dealt with all the defecation and everything else, unfortunately, that we need to do with. So do I feel that the policy has been followed? No, I do not. Do I think all the evidence has been considered? No, I do not. I do believe that there is mitigation that we could put in place. We could strengthen particularly our rough sleeping programmes. There's even more that I could talk about if you like, but we cannot make decisions just because they are unpopular, and we have to make the right decisions for unfortunately, for the residents.
Okay, well, as I've said earlier on, this isn't for this committee to make a decision, other than whether we choose to give advice to the cabinet or otherwise. But before I do that, I think, did you want to? No, okay, all right. Well, one thing is really coming clear out of here. There's not a meeting of minds, and I'm going to be asking each side to summarise in a minute before we discuss any potential motions or otherwise. But yeah, there's clearly not a meeting in minds here, and a number of issues have come up. And I think for me, the first one is probably what it said in the consultation document, which this was the original consultation document, where it says, we believe we have enough evidence, including overnight sleeping. That's exactly what, before we went out to consultation, the council was of the view that we have enough evidence. Okay. Now, when the subsequent consultation came through, when you look at each element, each one of the PSPOs, the same trend came out from our residents on every single case about overnight sleeping and sleeping in vans. All of our residents were vastly in favour of the PSPO as it was intended. And in fact, the overall result was also in favour of it. I can see you shaking your head there, Councillor Wilson, but you can have your chance to summarise in a moment. So that's really how. Now, so I think, the other issue is, who are we trying to protect here? Is it our residents? And there is plenty of evidence, because that's why it was part of the consultation in the first place, that there was a problem. And that's what the PSPO is trying to do, fix this problem. So this is one element of the problem that we still have that won't be fixed. But it's set in 3 different areas as well, isn't it? It runs across the 3 different PSPOs. So just taking that to the side, then looking at the legal aspects of it. From what I hear, the papers did not really cover the legal aspects sufficiently. Plenty of council advice, council of this, but the specifics of explaining why it was likely to be subject to a call, I don't think was particularly detailed. So my view is that we need to get this right, and we need to get this right now. And I don't believe that we need to wait another 3 years. I think, overall, I think we need more work on this, and I think it would be a mistake if we didn't take this opportunity with all this work that's gone into it, not to get it right, because there's clearly an imbalance between what we think we're allowed to do legally and what our residents would like us to do. And we're here to serve the purpose of our needs of our residents. Now, another thought has just come to mind, and that's about potentially penalising the homeless. Nobody wants to penalise the homeless, of course they don't. But actually, this piece of PSP applies to everybody, every resident, every visitor. It's not just targeting one particular group of people. It's for everybody. That's what PSPO does. So, from what I'm saying, you can obviously get the gist that I'm in favour of referring it back to Cabinet for them to reconsider some of these issues and to get them right. So we get it right now, and okay, it may delay things for a little while, but better get it right than have this lingering dispute about, the pros and cons of it. I think we do probably need to send it back to Cabinet and get to think about some of those issues that have been raised very articulately here today. So I don't think it's safe, frankly, at the moment. Councillor.
Just a very quick question. In the report, it says that council was going to be requested in July, and we're now in October. I wondered if we'd had any whether council had been requested and whether or not we'd had any answers from them.
Are you talking about legal counsel?
Yeah, legal counsel.
Okay, well, if we could just get an answer to that, and then what we'll do is I'll ask Councillor Broadhead and Councillor Wilson just to summarise their cases, and then we'll discuss whether we believe we need to make any motions. So we'll take each line item of these, and we'll either vote on each one individually or them collectively, or whatever. Is that a reasonable way to go? Bearing in mind that we probably need to think about, we have another meeting at 6 o'clock. We need a little bit of a. Thank you, Kelly.
Thank you. Just the point around council, the council's advice was sought as part of informing the cabinet report and the proposals that were put forward in July. So we have that advice, and that informed the decision that was taken at the time. Hopefully that's helpful to clarify. The other thing that I just wanted to mention is the options appraisal. And I hear what's been said in terms of the content of detail in the report, but there is a very detailed options appraisal that's summarised in the report, but does go into much more detail in the appendices.
That's the one that I read, Kelly. Thank you. Okay, so where was I? I think it's time to summarise then, and we'll give Councillor Broadhead the first one. So not more than 5 minutes, please. And say for you, Councillor Wilson, thank you.
I don't know what you're trying to insinuate, Chair. Well, thank you very much, and I'm genuinely grateful to the board for the content of the discussion, which was, again, as we reiterated time and time again, is not about the policy itself, but is about the decision making. And I think, agreeing with what you said yourself, Chair, this is a unique opportunity. We are not a decision making body here, but we do have a very specific opportunity to be able to say, based on our thoughts of whether this has been decided in the right way with the body of evidence that we would expect, to say to Cabinet, now's the time. Let's just think of this again, look at it again, because it is too important an issue to let go, and as you said, to just ignore for the next 3 years. When we put this call in forward, we brought 3 different parts of the decision-making process that we brought to the attention of the board for consideration, where we thought that there hadn't been the follow-through that we would like. The first one was 1.1b, which was around the decision, not just the decision-making being lawful, but the decision being lawful itself. And the reason that we put that forward was this continued advice that we've heard again and again about the fact that you couldn't do this because it wasn't lawful. And once again this evening, we've heard council said this, council said this. We haven't seen any of the body of that evidence, and indeed we have heard contrary evidence as well. So, when we're talking about whether the decision is or isn't lawful, I do think it is central because to our decision to whether to refer this back to Cabinet or not, because it was presented to us as a reason for that decision not being taken. Councillor Wilson also talked around 1.1e and the due regard to appropriate national strategic local policy and guidance, and referred in particular to updated national guidance, which he appeared to use as his gotcha with saying, well, we couldn't do this because government have said that we shouldn't be using PSPOs to target the homeless. And I absolutely fully agree with that statement. But as we've heard again and again, that is not the purpose of this PSPO. This PSPO, constructed properly, could actually enable those that are homeless to have even more protections. Because if you're saying there's a blanket ban on people camping, but you also have protections in place for those homeless, then as long as you know that the homeless people who are the homeless people are, then this is definitively not targeting the homeless. And indeed, in our neighbouring council, Dorset, there are provisions that have been put in there to reflect that. What he didn't talk about was the content of our actual call-in under that 1.1e, which was about the local policies. And we have an adopted corporate strategy, and in the connected community section, it says the council's objective is ensure our communities feel safe. And as you heard from Councillor Dedram, from Councillor Dove, and others, there is a degree of disagreement about that. And we've heard again and again from our residents that they do not feel safe in some areas where this happens. And we've heard about some of the stats, and countless there will be more. And there are other local policies that I just do not think were referenced in this report again. So I do not think that it has taken into account our current local policies as well. But I think 1.1h is the crux of the matter here. What options were considered and reasons for the decision? You very well articulated yourself, Chairman. There is an options appraisal in here, but the option appraisal says we're not going to do this one because we don't want to, because we think that actually the visitor, basically, essentially, the visitors don't want us to do it. And it is pretty much, there's not an exposition of pros or against. The options appraisal, it says that we're just not going to take this forward. And look, if you take that to the nth degree, you know, should the visitors be able to park for free if we canvassed them and they said that they didn't want to do it? Should they have free ice creams? Well, of course not. So I think an unfair body of weight has been put on a very small percentage of the consultation response. And as you've said yourself, evidence has been brought to the fore as well, in that we don't have enough evidence. Well, the consultation itself says that there was enough evidence. That's why we're consulting in the first place. But what we've heard again and again tonight is that, well, we need more evidence. Well, that's akin to saying, well, let's wait till it's really, really, really bad before we do anything. So I think each of those decisions has merit to be referring this back to Cabinet, but particularly that last one. I do not feel that this report has looked in detail enough at the options that were considered or the reasons for the decision. And I think it's absolutely the right time to just ask Cabinet to consider it again and look at this in the way it should be looked at. Thank you, Chair.
Thank you, Councillor Broadhead. Councillor Wilson.
Thank you. I didn't prepare anything for closing. I didn't realise that's what we'd be summing up. But yeah, I think it's been a really interesting debate, to be honest. I think it's been quite useful to hear everyone's opinion. But it really does, and Councillor Broadhead mentioned it, come down to the crux of the legality. And that's the biggest issue for me here, is the legal side of things. And I just don't believe that. I think we would be leaving ourselves really open fundamentally to challenge from organisations such as Liberty, who set out to defend people's rights. We are taking away people's rights. So you need a very high threshold of evidence. There simply is not that. And that's not me saying that. That's council advice, legal experts, external legal experts. When you mentioned about the advice taken to go to consultation, that was internal. When we went to consultation and we had this challenge, this response from Liberty, then council advice was further council advice was sought. Ultimately, I don't want to put the council at risk of reputational damage and financial damage, especially in the climate we currently find ourselves financially. And so I really cannot support this PSPO if it went back to Cabinet, because I trust my officers, I trust my legal team, I trust what they say. I am not the expert, even though I may sound like one. You know, I really do believe that we shouldn't be bringing this back to Cabinet. I think we followed every process to the letter, you know. So if that's what you're asking, and that's what I believe the call-in's about, then yes, we absolutely satisfied that. If you're asking whether you're happy or not with the decision, then that's a totally different kettle of fish. And I think that's got, like other councillors said, been conflated here. We've definitely followed all the processes there and all the other processes within the articles in the Constitution. And I'm absolutely satisfied with the decision we've come to through that process. It's unfortunate, you know, that we're facing some of these problems. I understand that, and we need to be doing more to deal with it. That's why we're reviewing it. That's why we're looking at options for people to have a site for camping. You know, we're doing things, we're approaching, we're being proactive. But at the end of the day, I am not going to put this council at risk of legal challenge. So thank you.
Thank you, Councillor Austin. Yeah, I understand that. Of course, we don't want the council to fall foul of the law. Absolutely, 100% not. And but we come down to the three arguments, and for me, the argument was that there wasn't sufficient evidence to go against the overall result of the public consultation. There was no evidence to support that particular decision. That I know there was some, one or two comments at the end, but I didn't think it altered the overall thing. Now I'm going to, okay, very quick.
Chair, I just wondered, because the committee can request to see documents, etc., can't they? So is there no reason why we can't see that council advice, is there?
Sorry.
So as chair of this committee, you can request to see certain pieces of documentation, reports, policies, etc. So there's no reason why we can't see that council advice, is there?
I don't know, but unfortunately we haven't got it here, and I think that we do need to move it on. I think we need to decide whether to refer it back to cabinet or otherwise, and I it'd be interesting to see what how the vote will go on it. So I think what we would do is make a proposal. Well, I don't know. I'm happy to lead on a proposal, but if anybody else wants to, so, without going into the detail, whether we want to refer it back to cabinet or we don't, and as simple as that. And then we can decide on the supporting reasons if we want to. Yeah, sorry.
I was just going to say that, Chair. If you do want to refer it back to council, it has to be with advice.
Yeah.
Yeah.
No, understood. Yeah. So, as members, would anybody like to make any? Councillor Dedman.
Are you looking for a seconder for what you just said?
I've not proposed anything. I'm going to leave it to the floor.
In which case, I'm happy to make a proposal that we ask cabinet to reconsider this and to think again. And as officers have pointed out, we can then flesh out the reasons afterwards. But to be honest, I think it might be as simple as 1.1e that we don't feel that adequate options were considered and reasons given for the decision. I think that's a bit of a cover-all of a lot of the issues that we've looked at tonight, actually, Chair. So I'm happy to make that and seek a second.
Chair, I think it may be a point of I don't think we can flesh it out afterwards. I think that we have to have it in the.
I agree, absolutely. So what we can have a vote on here is the principle of whether it goes back or not, and then we can then decide.
I think maybe if I just make a proposal that under Article 12, 1.1h, and just do that one, which is, because I think that does cover most things, that as a board, we do not think enough explanation was given for the options considered and the reasons for the decision, and ask cabinet to reflect on that basis.
That's a very good proposal. Do we have a seconder? Councillor Dedman.
Yes, happy to second.
Okay, so all those voting for that proposal, would you like to vote now? Okay. All those against? 7 against, so that is not carried. Do we have any abstentions? We have no abstentions. Yeah. Oh, sorry, sorry, Tony. Okay, so that is not carried. Sorry, Richard.
Sure, unless there's any further, I'm going to just say what the next stages are. So in the absence of any advice being offered by the board to cabinet, the decision may be implemented immediately following this meeting.
Okay, well, if we have no vote to put it back to cabinet, therefore de facto, that is the situation, and I think we come to the end of that debate. So that being the end of the discussion, I'll close it down and say thank you, members, and I'll see you at 6 o'clock. Councillor Darling, did you want to say something?
There's just a point of personal clarification, which I think I'm allowed to make. As I believe the officers have said, the point of discussion, the motion that was brought was centered around the decision-making process. but also concerns about the one item of that process, and that was the rough sleeping. And the officers and the and Councillor Wilson made a point that it's not set in stone, and that it can be the PSPO for rough sleeping can be revisited. So not rough sleeping for no, it wasn't what I thought it was. Wrong words. But that is the point that was made, is that it's not final. That the cabinet may decide to review this at a later stage.
Thank you. Okay, members, we'll see you at 6 o'clock. Thank you.
Of the things here, we actually got the full resolution of the cabinet, and item C, I'll just read out of the cabinet's resolution. Councillor Wilson will probably agree. It says actually commission a feasibility study for a designated space for vehicular sleeping, caravanning and camping. So that is still ongoing.
Okay.
I think we need to move on.
Okay,
I think we finished
I
the
think-
meeting.
I think
We need a break.
we've come to the end of this debate. I'm closing the meeting down. Thank you.